Mentioning.
My lord, I need to mention, my lord, upon notice to the other side.
Inclusion.
Inclusion for witness action. My lord, why I will say, my lord. This is the order passed by the coordinate bench on 15th of April, accepting the written statement, asking us to complete the affidavit of documents and discovery within 15 days. Notice given to them, affidavit of documents sent to them. Till today, they have neither given us any affidavit of documents, nor have they come for inspection.
Let it come in the list, then we'll decide.
May I hand over the documents, my lord?
Your Lordship, may I permit to mention a matter regarding CS 176963 of 1959. It was fixed for 16 January 2025 to submit notes of argument. Till date, the matter
Which one?
For notes of argument, Your Lordship.
Number?
GA17 and GA18, both of them.
What is the suit number?
CS 1763 of 1959.
What is the suit number? 1959?
Yes, 1959, Your Lordship.
It should not come.
Yeah, yes, it was parted, Your Lordship.
Which
And
one?
we were directed to file one note of arguments. And it was fixed for 16 January 2025, Your Lordship.
Okay, it will be included in the list. Come in the list.
May I be permitted to mention,
Grateful, Your
Your Lordship, this is a probate matter.
Inclusion.
No, Your Lordship, this is from 2017. It was already granted. There's a delay in filing inventory and accounts seeking.
Let it come in the list, I will allow.
May I permit to make mention, Your Lordship? Lordship, in a suit, I am the defendant. I have filed an application for extension of time to file WS, Your Lordship. Lordship, since it's a commercial suit, Your Lordship, I cannot able to some technical glitch, Your Lordship.
Let it appear in the list.
Lordship, but we cannot file because of upload.
Let it appear in the list. Let me see whether there time can be
cannot
extended
file,
or not.
Lordship.
Without hearing, I cannot allow it.
Lordship, no, my lord. I'm asking for leave to file the department physical copy, Your Lordship.
I have to check whether it can be allowed. Let it come in the list.
May it please your lordship, my lord. May I have your lordship's kind leave to mention, my lord, this suit is appearing tomorrow. We have filed an application being GS7 of 2025, my lord. We've served it on the other side, my lord.
Let it come tomorrow.
May it appear together, my lord.
Let it come tomorrow. We'll check it.
It's, the case status shows, my lord, it's there. If
এটাকে ফাইল করে কালকে দিয়ে দিতে বলো।
ফাইল হয়ে গেছে, সার্ভিস হয়ে গেছে।
It may come tomorrow.
Grateful, my lord.
Commercial division, item number 1 and 2.
1 and 2, my lord, I appear for the plaintiff.
What is J3 and what is
J3 is
J4?
an application for judgment on admission. GA4 is what my lord was hearing on the last occasion. This is order 13A. I am seeking summary eviction of the tenant, my lord. I am the long-term lessee in respect of the proper facts.
Summary.
My lord, may I just intervene? My lord, my learned friend's application is under order 13A and also for judgment upon admission. Obviously, my lord, and I say this with respect, hearing of the order 13A application will dispose of both the judgment upon admission as also the other application. I also have a suit, which is a non-commercial suit, relating to the same subject matter, which has now been specially assigned before your lordship. That suit is also appearing in the list.
Not this one.
Not this one. That is item 3 in the non-commercial list. My lord, I have taken out an application in his suit, which is now in the commercial side, saying that both the suits should be consolidated and heard together. Now, on the previous occasion, my lord started hearing of the order 13A application, but it was not concluded. If my learned friend wants to make further submissions, he is welcome to do so. I can then speak. Otherwise, if my learned... No, my lord, my lord has not heard me at all.
No.
Let
him file his notes of argument. Then I will hear you. I'll go through the notes of argument.
Yes. Well, the only other thing which I was respectfully submitting is, in my application, which I've taken out for consolidation of both the suits, if my learned friend wishes to use an affidavit, let him use it in the same time so that everything can be taken up together.
List, my lord. It's today not in the list, so I don't know if...
No, that is in the list.
No, I don't believe so. No.
Yes, item number 3.
GA3, item 3 is his suit. My learned senior friend has taken out an application, my suit, that is item 1 and 2. Another GA has been taken out. That's been served upon us, but it's not appearing in the list. That should be
that is J number?
Correct? I don't know. That is my...
Well, there seems to be some confusion with the numbering, my lord. My learned friend is not in a position to assist your lordship. My lord,
Anyway, let this you file a short notes of argument. Let me go through it. I will hear you. Definitely with prior service of you serve the copy prior.
Because my lord has not heard me at all, because I have a
Absolutely.
lot to say.
Absolutely.
Because your lordship will find, after hearing my submissions, it will be my endeavor to show to your lordship that without evidence, it is impossible to deliver any judgment in the order.
Whether it's a fit case for summary judgment or
Yes.
so and so.
So my lord kindly keeps that in mind, that I have not spoken as yet. Kindly keeps it then for another day, and let it be understood, if my
You are
learned
for
friend,
plaintiff.
if
I
my
am
learned
the
friend
landlord,
wishes
I'm
to
seeking
use an affidavit, it
That
need not go
application-
down in the order, because as my learned friend says, that application is not in the list. Let him keep that affidavit ready.
Yes. In
Learned
Kumula-
counsel, heard learned counsel for the plaintiff, namely Rampuria Industries and Investment Limited in part. Full stop. Liberty is given to file short notes of argument. That will be in GA3.
That will be in GA4, my lord. GA4 will take care of all the others GAs, my lord. If GA4 is allowed, then everything.
Both GA3 and of 2017 as well as GA4 of 2014, 24.
My lord, we can prepare a composite note if it commences tomorrow. Composite note, my lord, that will assist.
Notes of argument.
Fine.
This much notes of
Fine,
argument.
fine.
My lord will say, I will be heard on the next day.
On the next occasion,
No.
no, এটা লিখুন, after filing the notes of argument, Mr. Bosch, the learned senior counsel for the defendant shall be heard.
No, my lord,
And is also given liberty to file notes of argument as and when needed.
my lord will also allow us to just summarize the notes and arguments on the next day.
Whatever
because-
notes of argument in whatever manner.
Yes, my lord. After that, my lord,
Definitely not a voluminous one.
only my lord will
Your
allow
point
us
is
to
very
summarize.
short.
Very short. As to what amount of rent he is paying. That is all. If I go above 10,000, it comes under the Transfer Property Act. Pile vision is clear, my lord. That's all. The quantum of rent is the only thing.
Whether it needs evidence, whether it can be summarily delivered, judgment can be delivered
Yes.
summarily, all these things.
Yes, my lord.
Technical issues are there.
Yes.
File the notes of argument. Then I will hear, sir.
My lord, before Mr. Bose is heard, my lord will grant us only 3 minutes just to summarize. We'll file the notes
Definitely,
on it,
you
just
file
to-
the notes of argument.
Yes.
Let me go through it.
Yes, my lord. We'll do.
My lord will
Obliged,
fix a certain day, my lord.
My lord will grant us 2 weeks, my lord.
ওইটা যখন নেব।
My lord will kindly fix it after 3 weeks, my lord, so that we can.
Sir, if it is a commercial suit, why the
Yes.
other suit shall not be commercial?
My lord, because that doesn't come within the definition of commercial suit, my lord. That is why it may come back to my lord. Initially, my lord, that matter was appearing before my lord Justice Pottonaik. Then we made a representation before the court that both should be heard together. My lord was pleased to observe that unless Justice Pottonaik releases the matter, then only the matter can be assigned. Justice Pottonaik has since then, upon making a formal application, released the matter. We placed it before the Chief Justice. The Chief Justice has thereafter, my lord, passed an order assigning that suit also to appear before
In
your
that
lordship, because
case-
the facts are all the
In
same.
that case, let me hear these applications first.
Yes.
If the suit
that
is
will-
disposed of, then there
yes.
will be no question of consolidated.
And precisely, if the suit, everything will depend on whatever order my
The
lord
outcome of
chooses
this
to
app.
pass on the order 13A application.
Right.
My lord fixes a date.
My lord will kindly give us 3 weeks
Yes.
so that we don't default.
Yes, my lord will give us.
The date bother. Problem is that I have to allot some time to criminal matters. That is recently come to me.
We have seen that, my lord, and the Bar Library Club is up to protest. I can tell your lordship in advance, because we are enjoying, my lord, one of the few interlocutory courts which is presided over by your lordship.
Something is to be compromised.
Yes, it has to be.
Difficult to
not-
compromise
it is
witness actions because witnesses will come.
Absolutely, and it is physically not possible for your lordship. Of course, that is my personal opinion, to take 3 such determinations all at the same time. But however, we shall have to abide by whatever is decided.
কবে বললো? 12th March.
Very well,
Obliged.
very well, my lord.
না 12th March করো না।
That you're happy. If you want to file an application, file it, otherwise don't file it.
Date দিও না কিছু। Sir, you come collect the date later on because I have to fix a date, particular date for hearing those criminal matters. Let me decide this, then I will fix a date. You
My
get
lord
it at the
will-
end of the day
At the end of the day.
because before that
But
I have to decide which day I will fix.
Yes, but my lord will not make it prior to the first week of March.
No,
It'll only be after 7th March.
Obliged.
make it 10th March. 10th March হবে?
10th March. Yes. We keep it on the
11th March.
Well, on 11th March, his daughter's examination begins. He's been telling me 10th or 12th. Or I don't mind
All right, let it keep 12th. I will check it.
12th.
Item number 3.
Is my application. Number 3 is my application for extension of time to file my written statement. Your Lordship has,
GA6.
my lord, extensively heard it.
GA6.
Yes, my lord.
Yes, your lord. My lord, the moot point for consideration before your lordship is this: after the
You have shown a judgment.
yes, my lord.
Where is that?
Yes, Raj process equipments.
Yes. So this 120 days will not be applicable when the suit was written statement
Will not be applicable, my lord. It will be guided by
that you showed.
subsection 4 of section 15 of the Commercial Courts Act. And your lordship has the discretion, my lord, to extend the time. That is what the judgment, my lord, clearly speaks about.
Yes. What do you have to say on this?
My lord, I agree to the proposition that has come down from this judgment, my lord, that in case of a suit which is transferred from non-commercial to
That
commercial,
time frame will not be applicable.
120 days will not be applicable. Now, the only thing, my lord, is that even if 120 days is not applicable, it is not a matter of right. The petitioner still has to show just cause as to why.
When you'll
it
be
could
able to
not.
file WS?
My lord, it is ready.
My lord, may I just indicate?
Your
Perhaps
lordship
that
grants me today,
situation,
I'll file it today.
that situation cannot arise today, because by the first point that I taken was that in the petition, if my lord goes through the entire petition, not one single line which explains why they could not file the written statement after the summons was served. Second of all, my lord, they had taken out 2 to 3 applications before the suit was transferred, my lord. And by a recent judgment, my lord, His Lordship, the Honorable Justice Krishna Rao was pleased to dismiss their application for time to file.
Yes, I can remember this.
So this court is,
Liberty,
Please.
my lord.
so this court is not sitting in appeal of a coordinate bench who has already closed.
Subsequently, it was released. And that was hard. That was hard in the capacity of a ordinary jurisdiction.
My lord, may I just indicate the order which has shown, which has dealt with the application on merit, not released, but dismissed. Kindly takes up this application, my lord. Opposition. Kindly come to page number 11 of the affidavit in opposition filed by the plaintiff, my lord.
Will not debar the defendant to take appropriate steps. That liberty is given.
Yes.
I will pass order.
I'll just indicate, my lord.
I will pass order. Chamber দিয়ে দেবে।
No, my lord. My lord is seeing order date 13 February. 13 February, my lord will see the last line is neither have filed any application. This court finds the defendant only to delay the proceeding has filed the application on the ground which this application is misconceived. Kindly comes to page number. Kindly comes to
No,
page
no.
number 11 of my affidavit in opposition, order of 13th of February.
25th.
May I indicate? May I make my submissions uninterrupted?
Last liberty given.
Last
to me.
liberty may be given, but before
Yes.
that the order was passed.
Accordingly, this is the order dated
My lord,
25th
I am
November.
talking about 13th February, my lord.
25/11/24.
My lord will kindly then see the history of the case. 6 applications filed, that all of them were dismissed on merit. My lord, after considering the submissions, kindly come to page number 11 of my affidavit in opposition, order dated 13th of February. Kindly,
Mr. Mukherjee, I have gone through all the things.
my lord,
Please hear. I am giving him 3 days time. If written statement could be filed within this time, it will be accepted. Otherwise, it will be deemed that he has
my
nothing.
lord,
to do.
one can prepare on one day and file the written statement when the right is closed, my lord.
No,
Can
that
that
is
right
open,
be
kept
reopened?
What the
That
Supreme
would
Court
be-
has dealt with. If my right has
No,
been
kindly
closed
take-
under the my lord ordinary.
Yeah, this
division,
case also,
Yes.
right was closed but reopened.
No, this right was closed by the commercial court. My lord, kindly comes to paragraph 7.
Yes, where's the AO?
Kindly sees, my lord, once kindly sees.
No.
This is, my lord, this is,
I am seeing your AO.
yes, my lord.
This order in page 16 of your AO.
My lord, before 16 comes to page 11. What happened before that? My lord, 3 or 4 applications taken out. All of them were dismissed. Some were dismissed for default. Restoration was also dismissed for default. Kindly see page number 11, paragraph. My lord, order dated 13th of February 2024. Defendant has filed an application GA3. Today, my lord is hearing GA6. Defendant has filed an application being GA3 2023 in CS number such and such. GA3 was taken up for hearing. My lord kindly takes up the second page, my lord. I will just take to the right pages, my lord. My lord, page 12, middle portion. Now the application being GA3 is 2023 is taken up for hearing. Defendant has paid for recalling, modifying the order and paid for extension of time to file written statement. Counsel for defendant submitted. Writ of summons was lodged in 13/5/2022, but a copy of amendment being was served a day before the summer vacation. The specific contention of the defendant is that the defendant has engaged the counsel, but the learned advocate has not properly advised to appear in the court and file written statement.
Yes,
Now-
I've gone through it.
Yes. Now, kindly last paragraph of page 13. This court has inquired from the learned counsel for the defendant whether the written statement is ready or not. The same thing my lord is doing
What
today.
is the point of law? Just give me.
My lord, the court
reference?
has dismissed it on merit.
Right. Where have you stated this? Which paragraph are you referring to?
Yes, my lord. Paragraph, if my lord takes my affidavit in opposition.
GH.
Yes, my lord. GA3 from the order
No, no,
dated.
G, para G, page 5,
Yes, my lord. Para G as well as para E, my lord.
para
Where-
GHI also there.
My lord. Yes, but I'm only trying to show from the history that there are 5 or 6 different attempts
E is
made.
also there.
Yes, my lord. So what I am saying is that, and my lord will kindly look at the judgment. Just one paragraph I will indicate. So, my lord, even before the suit was, and another point had fallen from my lord himself, my lord, on the last day of occasion, that is, whatever is not done will be done after the suit is transferred. If the right to file the written statements was closed
No,
before
that
the suit was,
judgment is clarified that point.
no, that
Answer
is
this
why I
point.
want to show, my lord, in paragraph number 8 of the judgment that my lord, my learned friend has relied on. Paragraph 7, if my lord kindly looks at the judgment of Raj Process Equipments, kindly sees paragraph number 7 from the first page, right at the bottom, the last paragraph on that page. On an 11th of August, the District Court Jalgaon was designated as Commercial Court in terms of the Commercial Court Act 2015, and the suit pending on the file of the Civil Judge Senior Division was transferred to the Commercial Court. After transfer, defendant numbers 1 to 4, who are the appellants herein, moved 3 applicants for condonation of delay, recalling the order, and for filing of written statement. My lord, this was done after transfer. Here, my lord, the order that I just, here, my lord, here, my lord, the order that I just showed to my lord was made before transfer, and before transfer, the right was closed. This was, my lord, this case shows that after transfer, an application was made by the commercial.
My lord, then
Got
your
your
lordship
point.
kindly comes to paragraph 3 onwards.
My lord,
Clearly
I
shows.
leave it to my lord.
I will pass order.
My lord will
Military
consider
order.
the orders passed.
এটা চেম্বারে দিয়ে দেবেন। No reason to delay the matter.
Grateful to man.
Item number 4. Commercial Division, item number 4. Ashok Leyland Limited.
My lord, on the last occasion had called for a report from the department, my lord. Because there were some defects in the written statement and my lord.
Who are you? Who are you? Plaintiff.
Plaintiff, my lord. There were some defects in the written statement. My lord had called for a report from the department if that has been cured. And my lord, the defendants have not been appearing for over a year, my lord. So my prayer is, my lord, that this matter may be kept in the undefended list. So 2016, my lord, my instructions are that the defendant is not appearing.
When WS was filed. The report of the section officer dated 11 to 2025 be kept in record. It is stated that defendant has taken no steps to cure the defects in the written statement. Full stop. The defendant is directed to cure the written statement on or before the returnable date, in case of failure of which the written statement shall not be accepted and deemed to be rejected. In that case, full stop. It will be deemed that the defendant is not in a position to contest this suit, and the suit will be treated as undefended suit. Let the matter appear in the list on 24th March.
Item number 5.
My lord, I appear for the plaintiff. My lord, this matters for framing of issues. I have, my lord, affirmed my affidavit of documents served
Yet
upon
to be
the
done.
other side. My lord, inspection has not yet taken place, my lord. It is taking place tomorrow. But my lord, may I indicate, my lord, the
So I'm extending time for framing of issues, discoveries, inspection, all these things. Judge's brief is not filed.
Judge's brief is not filed. My lord, they have not even disclosed, the defendant has not even disclosed their documents.
Disclosure, discoveries and inspection of document as well as filing judge's brief of document is yet to be done. Let the suit appear in the list on 27th March for framing of issues. Discoveries, inspection, disclosure of document, admission and denial, as well as filing of judge's brief of document shall be complete in the meantime.
Obliged.
Item 6.
Item 6 will appear on behalf of the defendant petitioner.
What is GA4?
That's not my application, Milord, for dismissal of their suit because our cases in the application, that is in the nature of Order 7, Rule 11, that the claim is ex facie barred by limitation. I have argued the matter, Milord, and I have cited 4 judgments.
Well,
Lordship might,
today I have to make submissions.
Yes.
Lordship might recall, Milord, I have placed and referred to 3 paragraphs of the plaint. The plaint, Milord, it's twofold, Milord. First, their claim is based on, Milord, non-payment, though the supply has been made. And second, Milord, their claim is refund of earnest money. I say both the claim, Milord, that's barred by limitation ex facie. And Lordship has taken note of 3 paragraphs of the plaint.
Well, then may I make my submissions? I'm opposing this application.
Milord, paragraph, just that's paragraph 3, 4, 5. I have referred to these paragraphs and their claim, Milord, they have indicated, Milord, in paragraph 8. These paragraphs I have shown. And I have shown, Milord, the article, Milord, relied upon Article 100 and Article 14 of the Limitation Act. On the face of it, that's barred. Milord, if Lordship sees paragraph 3, Lordship, Milord, just, Milord, to recap.
Paragraph?
Paragraph 3 of the plaint. Lordship may recollect, Milord, what was, Milord, my argument. Last bill, Lordship would find plaint.
Yes, I've seen para 5, para 3.
Yes, yes. And kindly see when the Milord plaint was
4-5, 2013.
Yes, beyond the period of 3 years, number 1. So the first claim goes, and the second, Milord, with regard to their claim of refund of earnest money, that is based on a report which has not been challenged, and that they have pleaded in paragraph 4 and 5. That is also after 1 year. Paragraph 5, first sentence, Lordship finds the
in the mid of the sentence.
Yes, completely, Milord, to note the contents of the letter. This has not been challenged, and their claim is based on this letter that Lordship would find in this paragraph, which they have pleaded without challenging the same. They say it's bad, finding is bad, finding as.
But if we refer to 14/12/2010 as a date of cause of action, suit was filed within 3 years.
If Lordship takes that date as the commencement of the cause of action, but my respectful submission was, if Lordship sees, Milord, paragraph 8, possibly it can't be paragraph 8, their claim.
8.
Yes, Milord. 8.1.
From date of supply.
Yes. Now, Milord, kindly comes back to paragraph 3. When was the bill submitted? So supply has to be made prior to that date. It can't be after that. Paragraph 3 of the plaint. Paragraph 3. Duly submitted its bill on 14th.
Calculating from this date.
Yes. So commencement of the cause of action relating to their first claim is 14/3/2010 when they submitted the bill. And it has to be within the period of 3 years.
All right.
That is one, and the other one, Milord, the Article 100, because the report. And I cited, Milord, 4 judgments. Let my learned friend address, Milord.
Well, it may please your Lordship. My Lord, before I address you.
Let me take a note of this.
So commencement of cause of action is 14th March, my understanding. And that is their pleading also. Not 14/12. And this paragraph 3 has to be read with paragraph 8.
Yes.
Agree.
Well, it may please your Lordship. I appear for the plaintiff, and I'm opposing this application. Now, before I take your lordship into the merits of the claim and justification of maintainability of the suit, there are just 2 or 3 short things that I would like to bring your lordship's attention to. The suit was originally filed by me. Writ of summons was served. They did not contest the suit. The suit was heard on evidence and a decree was passed in my favor. When I went to put the decree into execution, they came up and made an application for recalling the decree. I should tell your lordship, even at the recalling stage, there was no point of limitation taken. I am not saying that he cannot take it, but this is an important factor which should be kept in mind. He made an application for recalling the decree. The learned judge, my lord, hearing the recalling application, was pleased to recall the decree upon them putting in the entire sum of money. They have put in the money. Thereafter, they made an application for extension of time to file written statement. They have filed the written statement. In no point of time and at no stage in the pleadings till then was the point of limitation taken. The suit was thereafter made ready for hearing. My witness was in the box being examined. It is at that stage that my learned friend took out this application, saying that my claim is barred by limitation. He had all the time in the world to take it. He allowed the suit to progress, even allowed the witness to get into the box the second time over, and thereafter, my lord, took this point of limitation. Now, keeping these factors in mind, which I personally feel in my humble and respectful submission should weigh with your lordship, my lord will consider the plaint. Now, in an application in the nature of Order 7, Rule 11, where the plaint is sought to be taken off the file because it's barred by law, and in this case, my learned friend says it's limitation, my lord will have to go by the pleadings in the plaint. And if the pleadings do not cast any doubt in your lordship's mind that the plaint should be rejected in limine at the very outset, my lords never interfere with the suit being progressed with and evidence being led. Here, evidence has already started to be led. Kindly, my lord, give me the opportunity to hurriedly take your lordship to certain paragraphs in the plaint. The guiding principle in reading a plaint is the statements in the plaint will have to be taken to be correct. I have judgments in support of that. Well, let kindly come to page 9, running page 9 of the application where the plaint begins.
Which paragraph of plaint you are referring to?
Well, at first paragraph 3. The plaintiff duly submitted his bill on 14th March 2010 for rupees 31,49,380 on the defendant for payment. After lapse of, my lord has got it.
Yes, lapse of long 9 months.
After lapse of 9 months, the defendant by its letter dated so-and-so allegedly intimated the plaintiff that the dolomites as supplied by the plaintiff was of substandard or inferior quality as appear from the analysis report of dolomite samples. So this is one aspect which my lord will have to go into, whether they were substandard or not. Now, there is another important clause. There was a tender floated in this regard, and the defendant placed an order. Paragraph 2, it is said, the defendant placed an order being number so-and-so, dated so-and-so, under the production officer for supply of so many packets of dolomite. Now, there is a particular clause in the agreement which is important. Kindly come to page 39. It is annexed. Mode of payment. Clause 17. My lord has got it. Page 39. Clause 17.
Mode of payment.
Yes. 20% payment will be released subject to following conditions: complete and satisfactory delivery within the limit of time, satisfactory laboratory report in case sample drawn and submitted. Rest 80% payment will be released subject to the following conditions: satisfactory field performance report where sample not drawn and sent to, full realization of payment by WBSSC, that is the defendant, from the concerned consignee.
May I just, sorry for intervening. This document has not been annexed.
No, it is in my affidavit of opposition.
That's a different thing. What
Plaint, only plaint is to be
It is in the application.
With the plaint. So I possibly, my lord, I believe, my lord, the law says only the documents annexed to the plaint and the plaint. So this document, my learned friend possibly cannot rely on.
Yes.
My learned friend is not correct, because when the document has been annexed and forms part of the pleadings before your lordship in the application which is in the application which has been taken out.
No, that's not the law.
Anyway,
I will cite.
Anyway, let my
Plain and
learn.
the annexures contains the plain.
Let me put it in my way. Then you
No,
might
but
walk
I-
away with all the
I take
kudos.
this objection.
Please.
So, rest 80% payment will be released subject to following conditions. Full realization of payment by WBSSC from the concerned consignee. So it was an open-ended notice. There is no evidence on record from the defendant as of now whether they have received the payment. Mine is a statement based on this document which says I've submitted the bill on 14/3/2010 for 31 lakhs and odd, and after a lapse of 9 months, he intimated the plaintiff that the dolomites are of substandard.
So these are
quality.
question of fact.
Question of fact which requires evidence. That is what I'm trying to say. That is what I'm trying to. My lord, kindly see paragraph 2. The defendant placed an order being number so-and-so, dated so-and-so under production officer for supply of 25,000 number of packets of dolomite at the rate of 50 kgs each to different blocks of district Nadia as per the terms and conditions mentioned in NIT number so-and-so, dated so-and-so, and the plaintiff accordingly effected the said supply. So the notice inviting tender is referred to in the plaint. It is not as if it is not referred to. It is there in paragraph 2. It is referred to in the plaint, and on the basis of that, I respectfully submit to your lordship, it was an open-ended contract. It is not clear whether he's received the full payment. Therefore, unless and until he shows that he has received the full payment long ago, and in spite thereof, he has not made the payment, and I have come up with a claim which is barred by limitation, he cannot succeed at the preliminary stage for taking the plaint off the file. That is not all. Now kindly take my lord, paragraph 5. Paragraph 5.
5 of plaint.
Of the plaint, running page 10. The plaintiff is completely surprised to note the contents of the said letter dated 14/12/2010 and immediately protested the said report on the ground that no sample of supplied dolomite
You
was
based your
ever
cause of action on this letter dated 14/12.
Yes, and these are questions of evidence.
And
These are
even
questions-
then, prima facie, the suit is within time, according to
time.
you.
And my lord, that there is another very interesting fact. Paragraphs 5 and 6 are very important because this is the evidence which your lordship will have to go into. Without this evidence, your lordship, I dare say with the deepest of respect and humility, your lordship will not be able to come to a conclusion as to whether the suit is barred by limitation or whether my cause of action as pleaded in these paragraphs is justifiable or justified or not. Under the circumstances, my lord, paragraph 8, refund of the earnest forfeited money.
All right, I got your point.
Now, kindly see what he says in his application. It's very important what he says in his application. First, he talks about the 3-year period.
Which para you are referring to?
But at his application.
Para 6.
Para 6. I say that the instant suit has been filed in May 2013, which is admittedly beyond the period of 3 years from the date of supply of the goods. No. It is not, because it is not yet clear whether you have received the money from your end supplier and whether you have, in spite thereof, failed, neglected, and refused to give me the money. It depends on the fact whether the report is to be given any importance based on the evidence. I shall call appropriate witness and then show to your lordship that the shield or the guard which he's trying to take on the basis of that report is not correct. So, my lord, this is the period of 3 years. And then paragraph 7, kindly see, the issues have been framed and the next date for examination of the plaintiff's first witness is fixed for so-and-so. The plaintiff has deliberately taken time on several occasions to delay the hearing of the matter, knowing full well that the plaintiff has no case. I have delayed the matter. You did not apply in the first instance. First time when the suit was heard. The suit was decreed after taking evidence. Decree was passed in my favor after considering the evidence. Decree was recalled and you were asked to put in the money. You put in the money. You made an application for for extension of time for filing written statement. I've delayed the suit. Thereafter, you filed written statement. I have delayed the suit. I have put my witness into the box. I have delayed the suit. Now you come up with the application and allege that I am responsible for delaying the suit when all these facts will have to be gone into. Now, my lord, kindly see paragraph 11. I say that though the plaintiff has not challenged the decision dated 14/12/2010 based on the report dated so and so directly, but the plaintiff's part of the monetary case is based on the aforesaid decision. So whether it's directly or indirectly and the basis of the claim, my lord will have to decide in an application under Order 7, Rule 11. The alleged claim of the plaintiff for refund of the forfeited amount of rupees 1,50,000 which the defendant has deducted is based on the decision of 14/12/2010. The claim of 21 lakhs and odd which the plaintiff has allegedly claimed as refund has also been notified to the plaintiff by the communication dated 14/12/2010. Without having the said decision or communication set aside, the plaintiff does not have the right to refund of 21 lakhs and odd in order to have such
So
a decision.
according to this paragraph, alleged claim of the plaintiff is based on this decision dated 14/12/2010.
Yes, and he says that I had just 1 year to challenge the decision. On what basis does he said so? On what how is the plaintiff supposed to disclose this? How is the plaintiff supposed to disclose this? The plaintiff says no part of the plaintiff's claim is barred by limitation. Your lordship will have to
Dev,
take
at this
evidence.
stage, it is very hard to decide.
And
I
then
will
my
hear
lord,
you on
then my lord, one day it fell from my lord that in any event, it is very clear that one claim cannot be decided. There cannot be part decree of a suit. Your lordship knows those propositions of law. There cannot
and
be part
plaintiff
decree
cannot
of
be
a suit.
dissected.
Plaint cannot be dissected. There cannot be part dissection. There cannot be part rejection of a plaint, part allowing of a plaint. So in this background, first of all, he says 3 years from the date of supply, when the NIT itself shows that the payment had to be made after he received full payment, and it is not yet clear whether he has received the payment or not. He says it had to be challenged within 1 year. On what basis he said that, I don't know. He may talk of an article, but when he says that the plaintiff is not supposed to disclose all that because all that will evolve at the time of taking evidence. And he says, although I have not challenged the report directly, I've based it on that. What I do in the course of evidence, what the witness says, what your conclusions your lordship will draw is something which will arise once, my lord, appropriate witnesses are called into the box and questioned. And more so, my lord, when the suit has started.
At this advanced stage, according to you, this cannot be dismissed.
It cannot
Or
be
the
done.
plaintiff cannot be
And in
rejected.
any event, my lord, it cannot be said that the plaintiff discloses no cause of action on a plain reading
No,
of the
not
plaintiff.
case of no cause of action. Plaintiff is barred.
Barred by limitation. No, I use the word no cause of action because I have primarily based my claim, my case on these two heads of claim. These two heads of claim, according to me, are not barred by limitation, and I'm showing your lordship why it is not barred by limitation. And since limitation is a mixed question of law and fact, unless my lord considers the questions of fact, I dare say, my lord, with the deepest of humility and respect, it cannot be done. Now, I have judgments, my lord, to show that the statements and the plaintiff have to be taken to be correct. I have judgments to show.
A lot of judgments are there.
Yes. If my lord so desires, I can put everything into a note. But
If you like, we can put it note.
It is entirely up to my lord. Otherwise, I can cite them here and now. It's entirely up to your lordship.
Then come with a note.
I'll come with a note.
Again, that problem is coming up. When I will fix the next text.
But my lord will kindly remember my arguments, my lord, that by no stretch of imagination can my learned friend's submissions be countenanced at this stage.
When was the earlier fixed?
12th. My lord keeps this also on the 12th of March. My earlier matter was just item numbers 1 and 2 was fixed on 12th March.
So, my lord, on that day, my lord, I would give reply to my learned friend's argument. I hope, my
Mr.
lord,
Dev, my problem is something else.
Oh, my lord.
I was telling, sir,
Oh.
I have to accommodate these criminal matters.
Oh, that's right. Now, my lord, the new determination has come. Absolutely. Lordship is burdened with criminal matters also. That's why I'd leave it to your lordship. I know, my
Both
lord.
of us,
Both of us.
Justice Rao and me.
Yes, my lord, absolutely.
But the Bar Library is, of course, going to try and make a representation before the Honorable Chief Justice.
No, that doesn't mean I will not hear the interlocutory.
No. The question doesn't arise. I'm just telling your lordship what is passing
I have
on
to
this
cut short.
side. Yes.
My difficulty, my lord,
Presently, I'm taking all 5 days, all interlocutory and other matters, possibly, and I'm taking up company matters 4 days a week.
lordship.
So some compromise is to be made.
Absolutely, my lord.
12, okay, 12.
12th.
Or I'm fixing it to the earlier date.
Yes.
আজকে হচ্ছে 13 12. Come on, 19. 19 কি আছে দেখো?
19th of February.
Yes.
Yes.
— 19th.
On that day, my lord, my learned
No,
friend
I shall take another 10
Very
minutes.
So thereafter, I will give a reply, my lord. I have got his point, my lord.
I'm very grateful to my lord.
Regular list. Item number 1.
Item of corrections. Give corrections. Make corrections and copy and hand it over.
The correction is only, my lord, in the cost title. This is an amendment application, my lord. In the cost title.
Correction of the order.
No, my lord, not correction of the order. In the proposed plaint, my lord, this is correction. This is an
এই
amendment
তাহলে
of the
এটাকে for
plaint.
correction লিখেছো কেন? Oh, that rating, it should be
Yes,
rating.
my lord, yes. Only leave, my lord, your lordship's leave is required, my lord, because the department otherwise is not able to carry out the order, my lord. Red, it has to be underlined with red ink, my lord. That's the only, my lord. If your lordship takes page 11, my lord.
দেখি order sheetটা দেখি.
Lordship is pleased to, my lord, grant the application, my lord.
Order, the proposed amendments of plaint was allowed in terms of order dated 29 January 2025. Full stop. However, the plaint containing proposed amendment marked as X. Now, line কেটে দিন. However, the proposed amendments were not in red ink. Full stop. The plaintiff shall file another copy of plaint or shall make correction in the plaint copy of the plaint marked as X by underlining with red ink those proposed amendments. The department shall act on the basis of that.
Yeah.
To date, 19th February.
Yes, 19th February.
To date for order.
My lord, this is the 19th of February, my lord, was for the suit, my lord, the main suit.
Let it come on the date.
My lord, the application has already been allowed by your lordship. My lord, the amendment.
Disposed of, it was disposed of.
Disposed of.
This is supplementary
My lord,
order.
on the 19th, my lord, the plaintiff.
What
The suit
further
is
order?
the suit. My lord, only this, my lord, if your lordship could only, my lord, delete, my lord, subject to what falls from your lordship. My lord, the first part of the order, my lord, it's not required for us to file any application. My lord, though lordship has given us alternative, my lord, to.
For which?
My lord,
No, I passed the order. What do you need and file an application?
No, my lord, your lordship has perhaps, my lord, recorded that I may file an application or may, my lord.
Not file application. Another copy of plaint with red ink, or you can underline
carry out the
or underline the proposed amendments with red ink.
All right.
Not application.
Grateful.
Item number 2.
Lord, I am for the defendant. This is my application, my lord, for a simple clarification of your lordship's order, my lord. My lord, what has happened in this suit, my lord? There is an ex parte decree was passed, my lord. Thereafter, we have filed an application under Order 9 Rule 13.
Which order?
My lord, the order is appearing as paid 151, my lord. Lordship's order, my lord. My lord has allowed the application Order 9 Rule 13, my lord, subject to payment of 75% of the decretal amount, my lord. Now, what has happened, my lord, in the decree, my lord, if my lord kindly takes up page 32 of my application, my lord.
59 lakh.
Yes, 53 lakh.
53 lakh.
Right, my lord. This is the principal amount plus the interest thereon, my lord.
Whether it's principal amount or with interest.
Yes, my lord. That is the difficulty, my lord. One more thing, my lord.
Principal amount, 75% of the principal amount.
Yes, my lord. So, my lord, kindly clarifies that. And my lord, what has happened during this continuation of this application, my lord, we have already paid 30 lakhs to them, and that they have accepted in their opposition in Order 9 Rule 13, my lord. Then, my lord, will get in page number 100.
Now, is it in your pleading?
Yes, my lord. They have accepted it that they have received 30 lakhs from us, my lord. This is, my lord, appearing at page 100, my lord.
Accepted.
My lord, kindly comes to their opposition, my lord, that they have filed in Order 9 Rule 13.
Filed an application for recalling of a decree.
Yes, my lord.
So look, this is for recalling or for clarification of an order dated
8 July
8 July
8 July
2024.
2024, my lord.
I
They have
did
not given me any money.
This is not the way of
No,
it.
I apologize.
I directed you to deposit 75%.
Percent of the principal amount.
Opposition means before passing this order, certain amount has already been given.
Right, my lord. That is 30 lakh.
So the remaining amount, I'm clarifying, the 75% of the remaining principal amount shall be deposited.
Very well. That has already been done, my lord. The remaining amount comes to around 10 lakhs and odd. That has already been deposited before the registered, my lord. That, my lord, I have the demand draft that is appearing as page 158.
So you come with a supplementary affidavit.
My lord, I have annexed the demand draft, my lord. That is at page 158 of this application, my lord.
But may I file my affidavit to it?
My lord, no such allegation is leveled against my the other side, my lord. So
But
Yes.
this is not this, then this will be not my rights will be curtailed. I'm proceeding with execution procedure.
my lord, kindly comes to page number 158, my lord. That is around 10
Should
lakh.
I stop him? Tell me just. Should I stop him? Or he should be out of court?
That's obviously not, but I have to not
All right, I'll hear you only. Say that.
very
I need not hear him.
no, absolutely.
Yes, my lord. My lord, kindly comes to page number 158.
There's a demand draft.
Yes, my lord. My lord, kindly read the register original side, High
This
Court.
is the amount of 10,17,000.
Yes, my lord. The decretal amount is was around
Right,
53
I'm
lakh.
clarifying that the balance amount, principal amount, 75% of the balance principal amount should be deposited.
My lord, that has already been deposited, my lord.
Then come with a supplementary affidavit, or let me have a report from the let the learned register origin side calculate, and what amount has been given that may be clarified from the report.
Very well, my lord. In the meantime, my lord, kindly, if my lord kindly stays the application execution, my lord. Otherwise, they are proceeding with the execution. For it can be done within a week, my lord. Execution is returnable on 27th, my lord, of this month. Otherwise, we'll be prejudiced over there in the execution, my lord.
In terms of order dated 8 July 2024,
Not. And he hears me out to not passing that order.
ex parte decree was set aside. Ex parte judgment and decree dated 26 February 2019 was set aside, subject to the condition that the defendant shall deposit 75% of the decretal amount with the learned register original site within 30 days from the date of order. A report is called for from the learned register original site as to whether the payment is made or not. The learned counsel for the plaintiff, your plaintiff, shall also furnish a statement or supplementary in the form of supplementary affidavit as to the amount, both principal and as to the principal amount he has received, if any, on or before the returnable date. The matter will appear in the list on 3rd March. Come with the report, then I will decide.
My lord, kindly just
I don't
clarify
need to
that.
approve the hearing.
My lord, kindly just clarify the decretal amounts is that principal amount only.
I will
Otherwise,
not pass any order right now. Let this report come.
very well, my lord.
Both of you, let the registrar as well as you file a supplementary affidavit.
Very well, my lord. Grateful to you, Lordship.
তিন নম্বর তো হয়ে গেছে।
Item number 4, 5, and 6.
I am for the plaintiff in this matter.
My lord, I appear for the defendant in this matter, my lord.
I don't will recall that it was my learned friend's application for dismissal of the suit for non-issuance of writ of summons. I had completed my argument, my lord. I had, my lord, cited 2 judgments. My learned friend, my lord, had taken time to consider them and replied.
My lord, if I may go back certain important pages of my application. So, my lord, the history of this matter. In 2012, this suit was filed by the plaintiff. In 2012, the suit was filed by the plaintiff. In 2012 itself, they filed an interlocutory application being GA number 1929 of 2012, my lord. My lord, that application came up for consideration before the Honorable Justice I.P. Mukherjee. If my lord takes up page number 63.
Sitting singly. Sitting single.
His lordship sitting singly. If my lord takes up page 63 of my application.
Which one?
That's GA3, my lord.
Page
63, my lord.
Yes.
My lord, here, my lord. If I read out the first paragraph, the learned counsel for the respondents assures the court that they would not cause hindrance to the plaintiffs enjoying the common facilities, areas, and conveniences of 28/1 Shakespeare Colony, Kolkata 17. Such assurance is recorded. In case of breach of such assurance, the petitioner is given liberty to apply. So it's not as if effectively any order is passed in this application. Merely my assurance is recorded. Thereafter, another assurance is given by the plaintiff. It is also pointed out that the petitioner has not paid for these facilities since 1994. Mr. Malik submits that if bills are raised upon his clients, they would pay the admissible amount. Let that be done, and I order accordingly. Let affidavits be exchanged according to the following directions. So, my lord, there was no actual judicial consideration of the application at that point of time. There was merely some undertakings recorded, an order passed for exchange of affidavits. My lord, thereafter, my lord, if my lord just turns the page 64, this is the order passed by His Lordship Justice Sanjeev Banerjee, as the Lordship then was, on 7th July 2014. My lord, I place the judgment. Since the plaintiff is not represented and none appears in support of GA number 1929 of 2012, despite the matter having appeared in the warning list, GA number 1929 of 2012 is dismissed for default. All interim orders stand vacated. There will be no order as to costs. So, my lord, first and foremost, the initial submission and the judgment on which my learned senior has placed reliance is that if an interlocutory application was filed, then non-service of the writ of summons is not a factor that will lead to automatic dismissal of the suit. Because my learned senior friend's contention is that you were there in the interlocutory application, you appeared in the interlocutory application, you were very well aware of the suit. However, my lord, if we see the conduct of that interlocutory application, first and foremost, we notice that there was little to no judicial consideration of it. There was an order for exchange of affidavits. There's no order taking those affidavits on record. And thereafter, my lord, because of the conduct of the plaintiff, when the matter was put down on the warning list, even thereafter, the plaintiffs were not represented. Therefore, the matter was dismissed for default. If my lord takes up their application, my lord.
That is GA3.
No, as in page number 40 of my application, my lord. So GA number 1929 that was filed by them.
Your application for dismissal of the suit.
Yes, my lord. Page number 40. Same application, my lord. So if my lord sees paragraph 20, in the usual course of things, my lord, the prayers of the prayers provided in the plaint are set out in paragraph 20. In the circumstances aforesaid, a cloud has been cast upon the right title and interest of the petitioner in the suit premises.
How the prayers of the plaints are relevant in this hearing?
No, my lord, what I'm trying to point out is that we also annex the plaint sometimes to the injunction application. The plaint even was not annexed here. So it is not this case. It's not the case that I was aware of an interlocutory application, that interlocutory application was considered, and I could
so
have.
Your point is they are very much conscious about these interlocutory applications. They appear regularly contested. So
they did not take steps to have the plaint ever served upon me. So it is not as if I was aware of an interlocutory application. I was aware of what the plaint was stating. There was just an interlocutory application filed.
You come in the form of notes of argument. I can't follow you.
Certainly, my lord. Certainly, my lord.
Because if your point is that if you have already appeared in the suit, you are the defendant.
I've not appeared in the suit. I've appeared only in the interlocutory application.
You are the defendant?
Yes, my lord.
So you file this application. You are very much conscious of pendency of the suit. Not
Certainly,
only conscious, you contested this.
only the interlocutory application. For every
Whatever
interlocutory
that
application,
might
separate
be.
wakalatnama.
When a suit is filed, as an advocate or as a litigant, you must know that written statement is to be filed. You did not take care to file written statement.
My lord, under the original side rules, for me to enter appearance in the suit by filing a wakalatnama, I have to return the writ of summons in the department. So unless the writ of summons
Notes
is
of
served,
argument.
certainly, my lord. Certainly, my lord.
The learned counsel is given liberty to file notes of argument. In both the interlocutory, in all the interlocutory applications, or I should take up confining to 3 only. GA3 of 2024, because this is a demurrer application basically. Let this be heard first.
Well, both of us should come back with her.
Yes. Liberty is given. তুমি এভাবে লেখো. The learned counsels are given liberty to file notes of argument in respect of GA 3 of 24. Let the matter appear in the list. Let GA3 appear only.
GA3.
Let GA3 appear in the list on 12th March. GA2 of 24 and GA4 of 24 shall not appear on that date in the list. Shall not appear in the list till disposal of GA3 of 2024.
But at GA2, where the interim order was passed, possibly is still today.
Oh, then ওইটা লেখার দরকার নেই। অর্ডার শিটটা দেখে একটু।
GA2. That's subject to correction.
লেখার দরকার নেই, কেটে দাও, একসঙ্গে আসো। Interim order passed in GA2 of 24 is extended till the returnable date.
Grateful question.
Item number 7.
What is GA2?
The GA2, my lord, is my application for rejection or in the alternative return of plaint, suit filed by the plaintiff, being my other side, my lord, Mr. Lahiri.
Where is Mr. Lahiri?
He was representing the railways, clearly a commercial suit.
Yes, I can remember.
Yes. My lord, prior to my lord arguments, my lord, I had filed a note, and subsequently, Mr. Lahiri has made arguments and has also filed a note. My lord, I have considered his arguments and made a fresh note incorporating and dealing with his
If
argument.
Mr. Lahiri appeared, then I'll reserve it for order. In his absence, I should not reserve for order.
Lordship is passing it over.
No, few matters are left.
I will kindly pass it over. I'll wait. No difficulty.
Not this week.
Will appear then on Monday. He'll appear on Monday.
Adjourn to hard in part, adjourn to 19 February.
Well, it could be 20th February, my lord.
20th, I'll be taking up the probate matters, testamentary matters. Then it will come on 21st.
21st.
21st হবে? No, not 21st.
Well, it can come up on Monday itself. If it's
Then in
this
May,
week.
then in March. 3rd March. 5th March. 5th March.
Very well. Well, I will take my note on record in the meanwhile.
Notes of argument filed by Mr. Medora be kept in record.
I'm grateful, my lord.
On behalf of the defendant, be kept in record.
That I can take back the earlier note which was filed, my lord. Otherwise, there'll be some confusion.
Yes, take it back. Liberty is given to take back the earlier notes of
I'm
argument.
grateful, my lord.
Item number 8.
My lordship, I'm appearing for item number 8. Actually, my senior is engaged in another matter, so I'm playing for not today.
What is GA7?
Lord, GA7, I believe, is for dismissal of the transfer of the suit. Now, Mr. Kormokar had taken an interesting point that suit should not be transferred, it should be dismissed, or the plaint should be returned. My lord,
When the suit was filed? 2018, that's why, based on Lokhi effect.
which is now,
You are plaintiff.
I'm the plaintiff, which is also now before the larger bench. But
An accommodation is sought for by the learned on behalf of the learned counsel for the plaintiff,
And for defendant.
defendant. Adjourn to 12th March.
I'm obliged, my lord.
Item 9.
This is chapter 13A.
Well, in this matter,
Issues are there. Issues, suggested issues.
this is an application under chapter 13.
Written statement file.
My lord, may your lordship,
Why framing of issues?
lordship, your lordship, on the last occasion, as far as I have got I'm just been engaged, my lord. I have got the order from the last order. Your lordship had sought for some report from the department.
Written statement has not been filed. I have given a report. Lordship said Lordship wants a further report. The matter, my lord, this is my lord, appeared, my lord, on numerous occasions, my lord. I don't, my lord, say anything since my learned friend.
My lord,
It is, my lord, adjourned, my lord, right from November, my lord. I have all the orders.
My lord, I'm not
Right from, my lord, first sickness, then, my lord, unwell, then it's some other court, then, my lord, lordship's called for
I
a
have
report.
only just been there are there are some problems are being faced, lordship. Your lordship kindly accommodates me for some time today for the last time as peremptorily. I'll not ask for any adjournment.
There is no written statement. I said so, my lord. Written statement has not been filed.
Why it is fixed for framing of issues?
I don't know, that was when some other order has gone in. My lord,
Because it was not, it was for filing of report.
report. This was for filing of report, my lord. I see the order of 9th of January.
Filing of report.
Because I gave a report of 2012, no written statement filed. Lordship's view was, my lord, 13 years have gone by.
Mr. Ghosh, you just think whether suit will abate against defendant.
Substitution done. Everything done.
Substitution was done.
Substitution was done, lordship. That I don't have those documents, but I'm instructed.
Oh yes. Substituted on 13/3/20.
20. Yes. Written statement will not filed, so they will have a right, will to proceed on the basis of the stage of the suit, will if they are substituted. That is, will the law on the subject, lordship has heard me on that. And thereafter, lordship to will get over any doubt, lordship called for a report. Because my learned friends who were appearing at that point of time were clueless, so was I.
The report of the learned registrar original site dated 6/2/2025 be kept in record. Full stop. It is in the report that the substituted defendants, who were substituted in terms of order dated 13/3/2020, passed in GA number 1866 of 2019, have not yet entered appearance either in person or through the advocate. Full stop. Accordingly, no written statement is there in the record or filed.
My lord,
I also did not file, my lord. These are the heirs, widow and the...
My lord, we are the heirs, lordship. What had
The
happened?
learned counsels for the
That's 2000.
substituted defendant, today 6 craves leave to file wakalatnama.
Well, wakalatnama was filed on the 18th of June 2024. But in the original side, there is a other way of their enter appearance has to be there. I think I'll instruct my advocate on record to enter the appearance, my lord, because it was filed on 18th of June 2024.
What were you doing?
Lord, I don't know. I've just been engaged, lordship. On 18th of June, the wakalatnama was filed.
Learned counsel for the defendant, substituted defendant, submitted that wakalatnama was filed on
18th of June 2024.
Then why this report is there?
I have a copy of that.
Not entered appearance.
Register is also not aware of the rules of the order. I am very sorry to say.
Well, because that
he couldn't have taken the written
without entering
appearance.
Okay.
I am very sorry to say, my lord, they are not aware of the rules.
My lord, a copy may
And
be
the
kept
heirs-
on record.
And the right of the heirs, my lord, continues whatever the father had or the original.
Absolutely. What is this suit about?
Suit is for, my lord, recovery of money.
Oh.
My lord, it's, my lord, I told
Not
my lord,
personal action.
it's not defamation.
No, it's not a personal action. It's a suit for money.
The suit for money. My lord, the defendant was to get a space where Sanjeevani nursing home in Shambhala.
Oh, yes, yes, I remember.
Remembers?
Yes,
They
yes.
could not give me the possession. So either I must get the possession or my money. In fact, that
My lord, I will make my appropriate. But the problem that today we are handicapped in this way, my lord. First of all, this is the widow and the daughter.
I understand, but whatever that might be, the Wakalatnama is to be filed as per rules.
That was filed on 18th June.
And Millard, if Wakalat and Millard written statement not filed in a, it's an undefended suit today.
Lordship,
And there's a
grant me
website-
some time. Let me go through the papers. All the papers are not with me. I have to instate.
First thing, you have to file an application because 30 days has gone long ago.
That, my lord, I'm not.
Application is dismissed. How can there be one more application?
Which
Father's
application was?
application dismissed.
They have not entered appearance.
Father's application, if right to file written statement disclosed, can the
Let them file application, you contest that.
Millard, kindly do not do that, Millard. I'll cite that. Millard, if the father's right is
They
closed,
first file application for allowing them to file written statement. Let that be heard.
that can't be done today, Millard. The
I
father's
am not
right is
what you can't understand. Problem is that you can't follow me.
How can it be done? That leap.
I am saying, I'm not saying let them allow written statement. I'm not allowing them to file written statement. That can be allowed at this stage. What do you understand?
Millard, they will file an application in an undefended suit to take on written
My lord,
statement.
this is
When they will file, I will hear it then. It will be filed in the department. You oppose that. For the timing, I will not allow them to file written statement.
Lordship.
At which I can allow them to leave to file Wakalatnama according to the rules.
Because Lordship kindly does
This
that.
much can be done.
I am not opposing that. I am not opposing
Yes.
that. Wakalatnama and interappearance, they have to do
Yes.
that.
Liberty is given the learned counsel to file Wakalatnama in terms of the original side rule. Let the suit appear in the list on 7th March.
Lordship.
I have an application also, Millard, in the chapter 13, Millard.
Is it pending?
It's pending. It's pending. There an opposition has been filed.
Where the opposition has been filed, he is correct.
GA7,
GA2.
GA2, Millard.
GA2.
GA2.
For hearing GA2 of 2012.
Lordship.
He has given
Full
an
stop. Since WS is not there in the record or has not been filed, the suit should not be taken up for framing of issues.
Lordship.
Grateful.
Lordship.
Great. I'll not be unreasonable, Millard, for filing Wakalatnama or interappearance defense statement.
Let them file. Now,
Definitely.
if they want to file an application, say for setting aside abatement or whatever that might be. So,
Amendment, here the suit has not abated and there he already submitted.
Files, I'll take them.
yes, if they want to file something, I will not.
You can't prevent, nor can I.
Yes,
Lordship.
that's
will
my
not take
point.
me that, not take me amiss. I heard it something else.
No.
Lordship will remove this. Glass.
Which one?
The glass.
Glass, Lordship. This glass is what is creating problem is our half the sounds don't come properly.
Lordship will remove the glass. Lordship will not take me amiss. Yesterday, Millard, that Millard exhibit marking, Millard. Lordship said, without marking, how can I send it? That will, how will I give my Lord?
I said that this is a document. This cannot be exhibited as of now. But some mark must be there to identify the document.
This mark takes us for that identification. What?
Not X. Anything.
Anything.
Any mark.
For
For just to identify the document. Say I have sent a deed dated the 1st January 2015.
Which is mark text.
If it is not marked, is subsequently a document returned, I find the document dated 1/1/2016. Then that's why court must identify this document with a particular mark, not exhibit mark. That was my point.
I have checked up.
Yesterday we were not in the mood of hearing.
Not both of us, Millard, we got tired. Both of us.
I was also hearing so many matters.
Both of us got tired. Millard, Lordship will kindly remove this. Half the sound is not clear.
Yes. এটাকে সরিয়ে দিও তো।
Here for plaintiff.
Item number 10, my lord.
What is GA2 and GA4?
My lordship, GA4 is my GA for application for additional brief of documents disclosure of additional brief of documents. My lordship, I'll just brief. My lordship had last occasion.
Additional judge's brief of document.
Yeah.
Have you any objection?
My lord, you have not received this application from the department, therefore I am seeking some time. Another thing is the
You
last.
serve a copy.
Yes,
I
my
will.
lord.
I will.
And another thing is, my lord, on 27 January, my lord has directed to take steps regarding the reconstructed written statement since it is not traceable. We have inquired from the department what to be done from our end. They had said that we have to grant leave, obtain leave before your honor so that we can file a reconstructed written statement, my lord. If your lordship kindly peruse that order, last order, my lord.
Furnish a copy of WS.
Yes, my lord.
Reconstruction shall be complete on or before the returnable date.
Yes, my lord.
So it was supposed to be complete on 12th February.
Yes, my lord.
It is not done.
No, my lord. I am seeking your lordship to kindly grant us leave to file the reconstructed affidavit.
I have already granted you leave.
But they are saying that since there is no leave is there. We have been, my lord,
The
kindly.
defendant shall furnish a copy for reconstruction. What leave should be given to you?
As your lordship, please. I
Who said this?
My lord, I have incurred from the department, my lord. They have said that I have sent it that.
No, no, no.
As your
Leave
lordship,
has already been granted.
as your lordship, I'll file it.
Time is extended to file copy of written statement for reconstruction of the record as contemplated in the order dated 27 January 2025. Full stop. Next para. The learned counsel for the
Plaintiff, my lord.
plaintiff shall serve copy of GA 4 of 24 to the adversary, namely Union of India. In course of this day,
My lordship, I will.
parties shall exchange affidavit, exchange oppositions, if any, on or before the returnable date. Let the matter appear in the list on 14th February. No, not 14th February.
Some time, my lord, I am seeking. 2 weeks before.
21st March.
Grateful,
My lordship, may I indicate one thing, my lordship, because it will come back again. My lordship has directed them to file, reconstruct the written statement. Thereafter, my lordship, the records of the court has to also be reconstructed in way of affidavit of documents and judge's brief of documents, because that is also missing from the records of the court. I'm just reminding my lordship, this was in this matter particularly. And after
Report is called for from the learned registrar original site as to
my lordship, it has already been done.
missing documents.
My lordship had given this direction earlier.
I had earlier given direction.
For judge's brief of documents also, my lordship, there has been a direction by this honorable court.
Is there any report showing that which documents are missing?
The department don't have any records after the plaint. And I have the previous honorable court's order, which is showing that we have filed the affidavit of documents.
A report is called for from the registrar original site on the condition of record on or before 24th February. They didn't come on 24th February. The matter will appear in the list for further order on 24th February. Prior to that, prior to the returnable date fixed as কবে বললাম?
21st March, my lord.
21st March.
Grateful, my lord. Grateful.
মানুষ একটু Yes.
My lord, we have permitted to make mention of extreme urgency, your lordship. My lord, I'm praying for leave to file a hard copy in the department, your lordship. We have filed preferring application, your lordship, but you have to require to file a soft copy, upload a soft copy with the website, your lordship. But you cannot do it because
Which
of,
matter?
well, this is a commercial suit, your lordship. It's not in the list, but it is returnable tomorrow, your lordship. But we are not
It
able
will come tomorrow in the list.
lordship, but
Tomorrow I
it,
will
it,
give you
but,
permission.
but lordship, it
This
will
is
not
not right
appear.
time for mentioning. Next matter, call the matter list.
For arguments, item number 11 and 12.
Well, I am for the petitioner and defendant.
Some
Defendant,
GAs are pending.
my lord, lordship has called for report from.
So just it. Some matters are pending still now.
I think by this time they might have become infractors, most likely.
Let those be disposed of at the time of final disposal of the suit.
May I, my lord, my learned seniors leave. My lord, these are the two applications filed, my lord, in 1995.
No, leave those things. I'm speaking of recent applications, 23, 24.
But I think 23, 24, my lord, serial number 4, my lord, the application seems to be arising out of CS number 4467 of 2022 and has been disposed of by an order dated 18 February 2023. We are not connected with that suit. Cost papers and the said application has been sent to
That
old
is
record.
CS, but instead of CS 576.
Absolutely, but it says about disposed of. That's a different CS number 4467. So we are not concerned with that. We are only concerned about the preliminary issue, my lord, in CS 576 of 1990, whether the suit is barred in view of non-compliance of section 31 of FERA. If lordship sees the report, that is somewhere not connected.
Let it be kept in record.
Absolutely, my lord. Let my learned senior, my lord.
My lord. May
Let me
I?
hear about it. Who is your other side?
My other side is Mr. Kothari, led by Mr. Ghosh. My lord, cross-examination was concluded on the last day. I, my lord, concluded.
Report of the learned register. Original site dated 11 to 25. Be kept in record. You are for?
I am for the defendant.
Are the learned counsel for the defendant in part? Adjourn to, we'll fix a date. Yes.
May I start, my lord? Lordship. My lord, before lordship opens the brief, let me give you overview of the matter. What's the matter about? Now, one, Mrs. Helen Wilson, a foreign national, to be precise, citizen of UK, United Kingdom, he owned a property in Calcutta. She entered into an agreement for sale with the plaintiff sometime in 1989. Now, since she was a foreign national, a permission under section 13 of FERA, which was prevailing, section 31, was necessary. Now, no permission was taken. Apart from that, an agreement was entered into. Then Mrs. Wilson cancelled that agreement. Cancelled that agreement. That cancellation has not been challenged. And the agreement, so-called the agreement for sale, that is neither properly stamped nor registered. Be that as it may, now we filed an application under Order 7, Rule 11 for dismissal of the suit on the ground it is barred under section 31 FERA or barred under provisions of FERA. The learned single judge said no, what you are arguing, that is not, I'll go by the plaint only. Going by the plaint, additional documents I cannot look into. We went up before appeal. Appeal court said that, well, this is a very moot issue, important issue, and this touches the root of the matter. And this should be heard as a 30-year-old litigation. And so this preliminary issue should be heard as a should be heard first as a preliminary issue. and whether it will be on trial on evidence or only
What is the preliminary issue?
that whether the suit is barred by law. On that, then that matter shifted from the various courts, various orders were passed. Ultimately, it was held that there will be trial on evidence. Now, trial on evidence is over. And the additional issue was framed on which trial on evidence was done before Lordship. Now, my case is that Section 31 read with Section 47 and 50 of the Foreign Exchange Regulation Act, any agreement is barred by law. It is illegal. If the agreement itself is illegal and void, then the suit is barred by law. Now, to that, the defendant has raised a question that they have shown that in that book, there is one form called IPI 2. That I form.
You are Jagannath Marotia?
No. I am the executor to the will of Helen Wilson. Now, I was subsequently added as different number 3 in this suit. Now, their case is that there is a IPI 1-2 form. Under that form, an agreement of sale has to be annexed with the application for permission before the Reserve Bank. So possibly, I say again, guess, possibly their case will be that agreement is not barred, but sale might be barred. Now, if the sale is barred, no court can pass an order for specific performance. And in any event, that IPI 2 form, that is a part of Exchange Control Manual of Reserve Bank of India, which is a guideline for the authorized dealers, that is banks and other authorized dealers, guideline. It has no force. It is not under the Foreign Exchange Regulation Act or rules. This is merely a guideline. So a guideline cannot override the law. So IPI 2, whether mentions agreement has to be annexed to the application, doesn't make that agreement a valid or legal document since barred under the section 31, 47, 50 of the Act. This is the whole very small scenario, very small scope of adjudication.
That is, we have to decide what is the scope of FERA, this particular section of FERA.
Lordship. That's what.
Now, and another distinction is there, whether the relief is barred or the suit is barred or the agreement is barred.
My lord, my case is agreement is also barred, and of course, suit is barred by law. Now, before that, my lord, the question will arise: what is the scope of inquiry before Lordship? And there are a couple of orders. May I place those orders, my lord?
Orders are not needed because you have to argue on the merit. I will hear it on merit without being influenced by any of the orders.
Very well. Lordship, kindly take up the amended plaint.
Amended plaint means 576.
570, Lordship.
What is in the other suit?
Other suit is EOPL. There is a
CS 11.
Yes, with my learned 3 suits, my lord. One is, my lord, UOPLA.
UOPLA is not here.
Suit.
That is separate.
Separate, absolutely, my lord. Now, my lord, CS 11 of 1994, that is a suit filed by Mr. Ghosh's client seeking cancellation of the will. In law, how far that is permissible, that's a different thing altogether. That is the suit. CS 11 of 1994, right now, we are not concerned. We are only concerned about this CS 576 of 1990, whether the relief as sought for can be granted in the given facts and circumstances of the case, considering the agreement. That's all. So that suit is also different suit, my lord. 11 of 1990. Though it's appearing in the list, but
it's very difficult to read the plaint. So many corrections are there.
May we do this?
There's a judge's brief of documents that we have disclosed separately. Page 1 to 20, Lordship sees the amended plaint has been annexed.
Come to the plaint first.
Let my learned senior lord place the
Lordship, take up the plaint.
পেজটা বল
রিলিফ হচ্ছে
page 11.
But Lordship is looking at our judge's brief of document disclosed by the plaintiff.
Plaintiff itself.
Yes, absolutely.
Three preliminary issues written in bold letters.
And running page 10, prayer my lord made in the
Prayer starts from page 8.
relief claimed, yes,
Substituted plaintiff's claim.
absolutely.
Decree for specific performance of agreement so and so. Decree directing the defendants to execute
the
and register.
The due form of law in favor of
In
substituted
default,
plaintiff.
register original side to do the same.
Hello, this is can suppose to run a business I need a license. I don't have a license. Can a specific performance be filed? You obtain a license, and is that binding on the government? Say,
So
for
there are
instance-
certain way to execute an order, to
Order.
execute a decree.
Anyway, my lord. So these are the prayers.
Order 21 says all these things.
Lordship.
How a decree can be executed in different suits.
Lordship. In default, the defendant executing such deed of deeds, convey ordinance court may appoint such appoint and directed to do execute register in due form of law. Such deeds
Specific performance in default as well as money claim of 5 lakh and in default of specific performance, decree of 635. 6,35,000.
that's all. Then a permanent injunction. This is the plaint. Now, Lordship looks at the amended written statement. In the paper book itself, it's at page 21.
You do one thing.
Lordship.
Come with a compilation. Compilation of cost papers. Plaint, written statement, issues, at least this much. And if possible, statement of witnesses as well as documentary evidence, so that I can need not look into those original documents.
I think that will be very good. That will be very good.
It will list a very
How long would you take to prepare this?
my lord, subject to correction with my learners, I can do it, my lord, by the weekend, my lord. Monday we can come back, subject to the
Monday,
convenience.
possibly I may not be coming.
Because Lordship is, my lord, now is overburdened, my lord. Criminal matters are there before a Lordship, my lord. So that's it.
Sure, Lordship will take up this.
Any day when it is convenient, but I can prepare it, my lord, with the help of my juniors by the weekend, my lord. I leave it to your Lordship, my lord, for the rest. In fact, it has been done. Just we have to give it a proper shape and hand over to the court, my lord.
26 February. ওই অর্ডারটা দিলাম ওখানে 26 February হয়ে যাবে।
Lordship, can it be little earlier?
No, I'm overburdened because I have to dedicate 2 days for criminal matters.
Lordship, given I have given the whole overview of the matter.
I have
Our
got it,
matter should not be long.
but I have to accommodate other matters also, other arguments also.
Absolutely, my lord.
And then 200 criminal matters. These are not determinations, especially SI.
But my lord, I think, my lord, one thing, my lord, I must tell you, Lordship, my lord, just what has been ascertained, my lord. On behalf of Balari Club, we have already given a representation, my lord, addressed to the Honorable Chief Justice, my lord, considering the case that hardly we have any, my lord, original side judges, my lord. Our suits and interlocutory applications are to be taken up. And if that is curtailed, my lord, obviously, my lord, we will have some difficulty because so many litigants are there, my lord, their cases are there, interlocutory
It's
applications.
a very heavy bench.
And
This should
my
not
lord
be
is taking
curtailed.
up suit and interlocutory application. And if half of the day is curtailed, or Lordship has to allot, my lord, a day for criminal
It's not
matters.
exactly curtail. I am shifting the case, these interlocutory matters in the second half.
Second half, so obviously, then second half will
Some
go and it will be devoted.
some
to the-
compromise is to be made.
So that's the thing, and we only have, my lord, 2 suits courts who are burdened with the interlocutory matters. So you have made a representation, my lord. Let us see, my lord, how what it happens. My lord. Grateful, my lord. We would come back on that day.
26.
26 তুই বলে অসুবিধা আছে কালকে?
26 now, একটু যদি আগে, my lord, may it be on 24th or 25th.
Then it will first week of March.
No, no, ঠিক আছে, Shyam,
Yeah,
my
26.
senior will be there. If I can't, my lord, my senior will
No,
be
no,
there.
why should we?
I will try to be.
Why
No,
should we
let us be on
decide?
26th.
Or
কালকে বল
27, 28.
My learned friend said 26.
Amendment
Stop
of
there.
plaint.
Lordship didn't hear anything, Mr. Ghosh. 5th and 18th, so that's 26th. Grateful, my lord. This happens. Grateful to your lordship.
Witness action, item number 13.
Yes.
I appear for the defendant.
Mr. Mitru, who are you?
Lord, I appear for the plaintiff.
Plaintiff.
Yes.
So
Lord,
it's your witness.
yes, my lord, I'll just indicate something. My lord, what had happened was we had obtained a decree. Defendants had not appeared. That decree, my lord, the judgment and decree was carried in appeal. There's an order by the appellate court. Now they have put in the money by way of a security. And my lord, now matter has to be retried. The written statement is on record. It's ready. Now, my lord, in the earlier time, my lord, my witness had deposed. Unfortunately, my lord, he was to come for cross-examination. My lord, unfortunately, my lord, he has left the services of the plaintiff and is no longer available.
So new evidence is to be added.
So, my lord, come with a new witness. my
Because
lord.
unless he is cross-examined,
Absolutely.
it will not stand.
Absolutely, my lord. Absolutely.
On prayer of the learned counsel, senior counsel, Mr. Mitro, witness action is adjourned to
My lord,
21st March.
Grateful.
My lord, insofar as the deposition that are already on record in respect of the first witness, they perhaps have to be struck off, or they have to be.
Let him come on the next date. I will pass order. If some new witness come and start to depose, then it will be expunged.
Yes.
Perhaps, anyway, it's for them, my lord. They will have to take steps, my lord.
That
It's
will
not
have
for me to
be-
advise them.
I will not expunge, but I will not take into consideration.
Oblige.
14.
14 for the defendants, my lord.
I am for the plaintiff.
Just before my learned friend starts, chief is going on. I would only beseech my lords if my lords grants another day for us to start the cross. That's it.
Finish, chief.
Much.
So I will not be able to finish today, my lord.
Let the chief be finished. Where is the witness?
Hello, PA.
Deposition. Deposition.
Kindly come to question number 6 of your deposition dated January 15, 2024, where you have deposed that you and the plaintiff number 2 is the joint owners of a flat.
Joint owners?
Joint owners.
Yes.
Where is the said flat located?
It is on the first floor of premises number 5, Clyde Row, CLYDE Row, Kolkata 700022.
When did you purchase the said flat?
That date, I think it is 18th May 2011. 18th May.
How many story is the building in which the said
is-
flat is located?
It is a G+4 storied building.
How many flats are there in total in the said building?
There are total 8 number of flats in the building, 2 on each floor.
How many flats do the plaintiffs own?
We own one flat.
How many flats do the defendants own?
They own rest of the 7 flats.
Are there any common areas in the said building?
Yes, there are many common areas in the building.
What are the common areas in the said building?
There are several rooms on the ground floor, including room for Darwan and security guards, generator room, control room for generator, meter room, 2 or 3 toilets, washroom, driveway for movement of cars, terrace and staircases.
When did the plaintiffs took possession of the said flat?
Immediately after the purchase, that is 18th May 2011.
Who negotiated with the erstwhile owners on behalf of the plaintiffs for the purchase of the said flat?
I myself along with my wife, who is also a co-owner.
Are the flats free from encumbrances, charges, mortgages, liabilities, disputes, attachments, etc.?
Yeah, yes. Disputes?
Etc. Milord, one thing inadvertently, Milord, the judge's brief was not filed, Milord. Milord, I'm just filing. Yeah, that's,
Have you served the other side?
we have served. It's a very glaring mistake, Milord, on my part. Kindly come to page 53, PD2 of the judge's brief of document. Three, corresponding to PD2 of the judge's brief of documents. Kindly tell my lord, what is this document about?
This is a conveyance deed which was registered. This is a conveyance deed which was registered with the Registrar of Assurances for the purchase of the flat.
Is there any date appearing on the said deed? Inside document?
18th day of May 2011.
Is there any signatures appearing on the said document?
Yes.
Is it registered or unregistered?
No, this is a registered deed of conveyance. Registered deed of conveyance. No, it's a
Is it copy or original?
It's a copy, my lord.
Where is the original?
My lord, original, my lord, I will be asking my lord questions, my lord.
Yes.
Can you identify those signatures?
Yes.
Please tell this honorable court whose signatures are appearing on the said document.
Two of them are by me and my wife, and the others, myself and my wife, the co-owner, and the other signatures are belong to the erstwhile.
Kindly encircle those.
X for identification.
My lord,
What are you to say encircle?
no, my lord, I will, my lord, ask him my lord questions. Kindly come to page 67 of the judge's brief of documents. Is there any signatures appearing on this document?
Where is the original document?
With the bank.
To the court.
They are with the bank. I've taken up.
Which bank?
ICICI Bank.
Which branch?
Bowbajar branch. Bowbajar branch.
The original deed is lying with ICICI Bank Bowbajar branch. Where is certified copy of the deed?
Certified copy of the deeds are with me.
Why it is not produced? Don't look at the lawyer. Look at me.
I was never asked to
mark X for identification. এই পয়েন্ট কোশ্চেন গুলো নেবে কিন্তু why certified copy is not there? I am not asked by the learned counsel. No shortcut.
No, I was asking, Lord. I would be asking. I was.
It is not here. What will you be asking? Certified copy is not there. When the original is not there, substitute is certified copy. It is not there, so it will be marked X for identification. Next question.
What about the contents of these documents?
When it is marked X for identification, why those questions should be asked?
Lord, I will bring Lord, in that event, Lord, may I bring the certified copy, Lord? I will.
Come with the certified copy, then depose.
Thereafter, Lord, I will bring.
PW1 is partly examined in chief. Further examination in chief is deferred to 17th March.
Without revision? May it please your lordship. If a lordship takes up company matters, my lord, by an order dated 27 January, lordship had granted me time of 3 weeks to carry out the amendment, reaffirmation, and verification of an amendment application.
In company matter?
In a company matter, your lordship.
Is it in the list today?
No, lordship, it's not in the list. The time is expiring today, lordship. The person who
come tomorrow. Let it be enlisted tomorrow.
Company matters. I
You
did
should
not
mention
receive-
it earlier so that it will come to the list today. All right, it will come tomorrow.
My lord, this is a matter of dissolution, my lord. And on the last occasion, there was an direction to publish an advertisement in the
I will not be
newspaper.
able to take up company matters as I am taking right now. Some time is to be compromised because of in view of some new determination.
New determination. So my lord is fixing some days for taking up the company matters because my lord takes it from Monday to Thursday. Can take it up on Tuesday, my lord.
No, Tuesday I will not take up. I will take it up Monday, Wednesday, Thursday.
Monday, Wednesday, Thursday. Only Tuesday, my lord will not take up.
Yes.
My lord, may I place my case? This is an application for the dissolution of the company, which was wound up in the year 1974. Now, my lords was pleased to direct the official liquidator to publish an advertisement and to file a compliance report. May I file the compliance report, my lord? We have not received any objection
Shodhpur
from the...
Potteries Private Limited.
Yes, my lord. We have not received any objection from any of the creditors, my lord. And now the fund position, if your lordship kindly comes to the report.
Report, which report?
The application, my lord. Not the report, my lord. Application, page 3. The present fund position is
4 point.
Yes, my lord. 4.
Is there any creditor?
No, my lord. There is the creditors means that only the Punjab National Bank, and they have not raised any objection because we have already made an publication.
No, do one thing. If they are secured creditor,
Yes,
they are
only
secured
one
creditor.
secured.
What
Only
is
one
the due
secured.
to the bank?
And nothing because they have not come up, and it is the winding up order passed in the way back in 74, my lord. And nothing has happened.
Come with the creditor.
And we have already made the publication, my lord.
Auditor certificate.
Yes, my lord. That can be done.
You have stated this in certain necessary.
Yes, my
auditor certificate on final accounts.
Yes, my lord.
An auditor be appointed. Let the High Court appointed auditor be there.
They're all the impaneled.
Impaneled from any impaneled.
Impaneled auditors, my lord. If your lordship
The
so
Garnet-
pleases, indicates the name of the auditor, my lord,
I do
he
not
can
know
be
the name.
engaged because the name is with the air.
Just a minute. Let the original register original side may appointed a competent person. Why should I appoint?
Then my lord indicates
Compliance
that
report-
the register original
Yes,
side.
compliance report is filed. But in other matters, I have passed order without specifying who will be the auditor.
Yes, my lord. Because
So you
usually
file
the
that immediately
auditors,
order?
are appointed. They're all the impaneled
One
auditors
thing,
of the
come
official
with an
liquidators.
application for clarification.
With regard to which matters means
where auditor certificate is
auditor
conferred.
certificates. For further clarification, who will be appointed as an auditor?
Yes. Clarification, modification, whatever you like to say.
For recalling of the order, recalling
No,
application.
not recalling means the whole
the
thing.
entire thing. It's only the modification, with
Modification.
regard to that.
Compliance report is filed by the learned counsel for the official liquidator, showing publication in one Bengali daily and another English daily, well circulated in Kolkata.
My lord also kindly records it that no objection is.
Publication was made on 10 January 2025. Full stop. It is submitted that till now, no objection is raised by any from any corner. Full stop. The application shows that Punjab National Bank branch is not shown. Which branch?
Branch.
Punjab National Bank is a secured creditor, but no objection has been raised on behalf of the bank. It is in the application that the present fund position of the company in liquidation is 4,01,397. Full stop. In terms of contention made in para 9 of the application, a certificate from an auditor, empaneled auditor, may be obtained in terms of Rule 281 of the Company Courts Rule 1959. Full stop. The learned registrar original side may appoint a suitable person from the panel of the High Court as auditor. The learned registrar original side shall select a suitable auditor from the panel of the High Court in this regard. Let the matter appear in the list on 27th March.
Deeply appreciate.
Sixteen is my application, my lord. Here, my lord, this is an application for stay of the winding up. Now, in terms of the order passed by the earlier coordinate bench, we have paid the entire dues. Matter has been settled. Everything is over. We have paid a amount of by banker's check 1,64 lakhs to my learned friend representing the official liquidator for payment to. There were 3 persons who were entitled to payment: Port Trust, the bank, and third is the workers. Now, my lord, my learned friend on behalf of the liquidator is to file a report in terms of the last order. Steel Authority of India Limited, Port Trust, and the workers.
Your lordships kindly turns to page 7, my lord. That was
Just one thing. All these secured creditor banks have already been paid earlier.
You see the order dated 3rd October 2024. My lord, page 9. Page 9 is the, my lord, the statement of outstanding, my lord. Your lordships kindly see United Bank of India, their claim has been settled and full and final payment. Bank of Calcutta Port Trust. Calcutta Port Trust, my lord, your lordships kindly turns to page 5, where I have stated, my lord, that to whom I have paid the entire amount. Page 5, paragraph 9. And my lord, I have stated that I have paid an amount of rupees 71 lakhs. Where have you stated? My lord, page 9, my lord, paragraph 9. Official liquidator has paid rupees 71 lakhs 18,860 2004 and rupees 11 lakhs to the Calcutta Port Trust. The settlement of the ex-workers are in process. My lord, it is the case, my lord, of the CP is 85.
Binding of order is 85.
Yes. So, my lord, there are no, actually, according to you, according to this report, UBI Bank of Baroda settled in full and final.
Yeah, they were earlier paid.
And ex-workers, my lord, your lordships kindly see, we have paid, my lord, the total paid 37 lakhs 79,009. Settlement of ex-workers are in process. Yes, that is, my lord. With the remaining amount, is it complete or not? No, my lord, because there are 57 workers as per the list of the official liquidator. And my lord, your lordships kindly see winding up order. Okay, so 1985. So far as ex-worker are concerned, the claim is yet to be settled. Yes. So far as claim has been settled, but payment I cannot. Payment are yet to be disbursed. Yes. So far as Steel Authority, SAIL and CPT is concerned, they have paid. It is only thing is disbursement to ex-workers. Yes, only thing. Your lordships can pass an order of stay. I have got no objection.
Yes, my order in terms of Pre B of the judge's summons.
No, I can't understand.
May I explain? May I explain?
If this cause of action for liquidation no longer remains, so the
application can be disposed of also.
Disposed of.
Yes, but only thing Lordship has to then sign the
Because
Lordship
if
has-
it is stayed, problem is that.
No, I'm saying I'm giving Malab, what we do normally in the company code earlier, Malab, when the application is pending, there is a stay of the binding up. When the application is finally Lordship is allowing, at the time of final allowing, then Lordship passes on the permanent stay. We add the word permanent stay. And here, Malab, this is a stay because
So
we have
only thing is disbursement to the workers.
that is that we have already given of full amount.
Please let me say. Unless that process is done, I cannot say the fully things are done. Fully things are okay.
Yes.
So there.
Yes, I followed. Correct. I'm so sorry.
Temporary. So the process will be pending only for disbursement to the ex-workers. Otherwise, this matter will not be proceeded with.
Yes. May I just?
If I pass the order of stay, then whole thing will be stayed.
No.
Disbursement will also be stayed.
No. That is not that.
Thing is, the official liquidator not to take any steps against the assets and properties of the company, save and except disbursement to ex-workers.
Yes. Lordship may kindly clarify. Order prayer B is for this binding order to stay. In the meantime, the liquidator.
The report of the learned official liquidator is placed pursuant to the order dated 3rd October 2024 and 22nd January 2025. Full stop. Sum and substance of the report is that there were 5 claims raised by United Bank of India, Bank of Baroda, ex-workers, Steel Authority of India, and Calcutta Port Trust. Full stop. Claims are fully and finally settled with these creditors except the ex-workers. Full stop. Part payments were made. Please. So far as United Bank of India, Bank of Baroda, Steel Authority of India, and Calcutta Port Trust are concerned, their claims are fully and finally settled. Full stop. So far as the ex-workers are concerned, part disbursement was made. They are partly paid by the official liquidator. Kindly takes ex-workers amount admitted, 1 crore 19 lakhs 31,000. Where is that? That is in page 9. Item number 3. Ex-workers kindly see the admitted amount 1 crore 19 lakhs 31,000. Admitted amount payable to the ex-workers are 1, 19, 31, 893. Out of which they paid 37 lakhs 79,914. Where have you stated this? That is the next 2 column after
the chart.
Chart in the out of which a sum of rupees 37, 79, 914 has been paid, leaving a sum of rupees 81.
Aste.
What is your name? Why you are here talking with him when I am dictating? Are you newcomer in this court? Has been paid, leaving a sum of rupees 81, 51, 979 outstanding. Now this amount has been paid by, who are you?
I am the applicant.
By the applicant, namely?
Oblique contributories. Applicants, there are more than one. Applicants, oblique contributories.
Applicant, oblique contribute. What is your name?
We are for many of them. Asha Rani Poddar, Vikram Poddar.
Applicant of the contributory. It is submitted that disbursement to the official by the official liquidator to the ex-workers, so far as balance amount is concerned, is in the process. Full stop. In view of the fact, as it is prayed for, the instant proceeding is stayed till further order, except to the extent that disbursement to the ex-worker shall continue and be finalized. Full stop. The official liquidator shall not proceed with the instant liquidation proceeding, winding up proceeding any further until further order. Full stop. On disbursement of the full amount to the ex-workers, a report shall be submitted by the official liquidator. The matter will appear in the list after 8 weeks.
Only one thing, I didn't interrupt. Lordship has used the word the instant proceeding instead of the winding up order July 4, 1985 be stayed. Only order has to be stayed. Prayer B of the judge's summons. July 4, 1985, order be stayed. Instead of the word.
Where is the
judge's summons? Prayer B of the judge's summons.
Prayer B of the judge's summons
Right.
is also allowed.
Great.
After 8 weeks.
Yes, after.
I'm not fixing any date.
Yes. Great.
Liberty to mention.
With liberty to mention.
17.
This matter, I am appearing on behalf of the official liquidator Lordship. Lordship, I am
Valuation report. Have you seen the report?
আমরা যে সেলটা করছি এখন প্রপার্টিটা ওন পাটুলি না 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 পাটুলি তো না এটা হচ্ছে শান্তিপুর বাচ্চারা নদিয়া
বুঝতে পারছি না কোনটা হবে। আমি এটা কাটছি কেটে দেখাচ্ছি তাই এটাই কত proof?
এটা কি ভ্যালুয়েশন রিপোর্ট
দেখুন দেখুন
এখানে হচ্ছে পানাগড় ডিস্ট্রিক্ট নদিয়া ওয়েস্ট বেঙ্গল এটা হচ্ছে বাগাছাড়া শান্তিপুর
এটা
2016 এর ভ্যালুয়েশন এটাই আছে Lordship, today my
Ki Kumra. Mouja Muti Kumra. Where is it? Built up area of 8920 square feet, block Ranaghat 2, within jurisdiction of Nokari Gram Panchayat. PS Ranaghat district Nadia. Is it the property?
Land measuring about 169.39 kathas situated at Bakchara, Shantipur, Gram Panchayat,
No, no, no.
Bakchara district, Nadia, Lordship.
No, no, no. Not this one. Just a minute.
Lordship, today I have come with an applications for advertisement of sale of the property mentioned
No,
at
let me check this one. What are you saying? Several valuation reports are here.
Yes, Lordship, there are, because 8 properties are there.
Which you are speaking of?
I am speaking of this serial number 4 of my applications. If you Lordship,
Structure.
uh,
What is the specification?
land at measuring about 169.39 kathas situated at Bakchara, Shantipur, Gram Panchayat. This one. All the properties were sold. Only this one and serial number 8 is there.
Valuation of number of things are there.
আছে ওখানে আছে ভ্যালুয়েশন রিপোর্ট আছে
Baganchra.
বাগাছড়া শান্তিপুর গ্রাম পঞ্চায়েত বাগছড়া district Nodia.
What is the area of land?
169.39 kathas.
No, no, that is not there. It is in terms of acre.
ওটা কি আছে আপনার কাছে আপনি ওটা দিন চিঠি
One property is mentioned lying in this Baganchra or something like this in Shantipur.
Yes.
But what is the dark number?
Details are not here, Lordship. With me, land measuring about 169.
Come with the particulars of land. Otherwise, it will be very difficult to match it.
Difficult, yes, Lordship. I will talk.
You are saying of in terms of katha.
Yes.
But we are mentioned in terms of acre.
Yes. That's same.
What is your prayer right now?
Lordship, my prayer, as per pursuant to the order of the Supreme Court, Lordship, which I have annexed in my applications, if your Lordships kindly come at page 17 of my application.
Now, details of assets location. You have mentioned 8 items.
Yes.
Now, in all these items,
yes,
you have mentioned what your description is land measuring 6.6 bigha so and so.
Yes.
But so far as any land, when any land is situated outside the territory of city of Kolkata,
yes,
there must be dag number, khotiar number, these
everything,
particulars.
everything.
It is not here.
In
The learned official liquidator. না এইভাবে লিখুন CA 26/24 is filed by the learned official liquidator on behalf of the learned official liquidator praying for publication of notice for sale of the properties, immovable properties, detailed in para 7 of the application.
Serial number 4, para 7.
In particular, the property located, property mentioned in serial number 4 of the table. Full stop. The learned official liquidator shall furnish particulars of the land but the same is absent here. A supplementary affidavit shall be filed in this regard for passing necessary order containing particular details. Full stop. The official the report of the valuer kept in sealed envelope is open today. Let the same be resealed and kept in the record. The matter will appear in the list on 20th March. Mm-hmm. 28 20 তাহলে 20 মার্চের 20 তারিখ 23 So far as this is concerned, these are two different CPs. I passed an order.
In respect of item number 18, my lord.
Yes.
Yes, my lord. Prior to the passing of my lord's order dated 16 December, 16 December 2024, already the company was transferred to the NCLT video order dated 16 December 2022, my lord. Now the entire records, I believe, have been transferred.
Is it so?
Yeah, because already there is an order of transfer. CP is same. Maybe the CA is different.
No,
CP 760 of 2013.
This is CP 661 of 13. CP 661.
Maybe there are different CPs where these winding up orders have been passed, but
check it. Just
yes,
check it.
but this particular CP has been transferred. So this company entire records have been transferred, nothing repairs because the company is same.
You come with that next day.
Yes,
go through it. Not this week, Kordin.
May I bring the notification because the notification is the
check this.
yes, my lord. Yes.
19. Company is the same.
The same, my lord. But only the CPs are different.
Maybe,
It
but if the
usually
company is
happens
the
in
same,
different
and
CP numbers.
If one liquidation proceeding is pending against particular company, then all the winding up proceeding shall be transferred to NCLT. So there is no wrong in this order. Anyway, come on the next week, come on the next day.
May I bring the notification?
Yes,
because the
possibly because
notification which has been sent to the ROC also that the entire thing is
if
has
a
been transferred.
liquidation proceeding is pending against a company, there may be 50
liquidation orders.
All should be consolidated in a
Yes,
single
my
forum.
lord, because yes.
Come on the next week. 19.
Lordship, I am for the official liquidator. Lordship, I am praying for filing a report, Lordship. On last occasion, your Lordship has directed upon me. If your Lordships kindly come at page 6.
Closing balance is 17,475.
Nothing is there, Lordship.
Still a report is needed. Certificate is needed for passing final order.
No, Lordship, what happened if your Lordships kindly come at paragraph 2 once? That the official liquidator submits that since neither any assets nor any amount has been obtained by the official liquidator High Court Calcutta
Right.
till date.
It is must that an auditor certificate be produced.
Yes, but the closing balance of the company is needed.
Even it is zero. Because that is statutory provision. I cannot give a go by to it.
In that event, if your Lordships kindly give 3 weeks, 4 weeks
Yes,
time.
yes. An auditor certificate is needed in terms of Rule 281, read with 282 of the Company Courts Rule 1959. Top learned registrar original site shall appoint a suitable auditor from the panel of the High Court, of this High Court, for this purpose.
And Lordships kindly record that I have filed a report, Lordship.
Full stop. The report filed by the learned counsel for the official liquidator be kept in record. The report shows a sum of rupees 17,475 is at hand.
Lordship, as an advance from the official liquidator establishment charges.
As an advance?
Yes, Lordship. As an advance from the official liquidator establishment charges, Lordship.
From the
Lordship,
official
when there is no
liquidators-
fund, we have to take the money from that fund.
Liquidators establishment charges. In other words, there is no fund available in the company in liquidation. Let the certificate be produced, as aforesaid, on or before the returnable date. The matter will appear in the list on 2nd April. With liberty to mention.
Lordship, in this matter, I am for the official liquidator. I am filing a status report, Lordship, in this.
Lordship, I am appearing for the petitioner in CA 17 of 2023, Your Lordship.
Report to the. Have you served copy?
Yes, Your Lordship. Lordship, by an order dated 5th January.
Have you anything to say against this status report?
Lordship, we have not been served a copy.
No, we have not.
Status report is filed by the learned register, learned official liquidator. Pursuant to the order dated 11 July 2017. Full stop. Copy of this report may be handed over to the counsels appearing herein. Copy of the report dated 24 January 2024 be handed over to the counsels appearing for the parties.
Lordship, I don't have any extra copy. I have only one copy. Let them write a letter to the official liquidator. They will give. Because I don't have.
No issue.
Lordship.
Learned official liquidator, it implies that a copy will be made in the office and given.
Yes.
Let the matter appear in the list.
Lordship, one thing, Lordship, by an order dated 5th January 2024, your Lordships had directed the respondents to file their affidavit in opposition and 1 week time to us to file affidavit in reply. Your Lordship, they have not filed anything. I'm just praying in case they don't wish to file any opposition, the right be closed and the matter be fixed for hearing.
I'm appearing for respondent number 1, 3 and 4.
27th March. Exchange of affidavit shall be complete on or before the returnable date. In case of failure of which, it will be deemed that no affidavit is there to offer.
My lord, a liberty should be given to file a wakalatnama in a department for respondent number 1, 3 and 4, my lord.
Liberty is given to the learned counsel for respondent number 1, 3 and 4 to file wakalatnama in the department.
Much.
Grateful, your Lordship.
This is item number 20 or 19?
20, your Lordship.
তুমি 19 করে রেখেছো কেন এখানে? ওটাকে 19 করে রেখেছো কেন? আমাকেও চমকে দাও নাকি? তোমাদের বাটন ঠিক করতে হবে।
21. Lordship, in this matter also, I am for the official liquidator. I am filing a report, Lordship.
Report of what? What is the balance amount?
Balance amount is huge, but it is not lying with us. It is lying with the secured creditors, Allahabad Bank, earlier Allahabad Bank. Now it's.
What is in your report?
Lordship, I have stated everything in my report, Lordship.
Report dated 6th February 2025 is filed by the learned counsel for the official liquidator. Let the same be kept in record. The matter will appear in the list on 27th March.
I'm great.